and work on this.
I call the honourable member Shane Ardern.
Mr Chairman, and I'm sure you'll come to understand that that was a very good call over the next few minutes. Biosecurity law reform bill is a very, very important piece of legislation for this parliament. In fact, one of the things I do agree with the previous speaker is biosecurity, Mr Chairman, is one of the most, if not the most important issue facing New Zealand in terms of securing a sound economic base and a solid economy to go forward on. In fact, increasing trade and travel volumes represent enormous challenges to this industry or this government agency. Around 170,000 items a day come across our borders, an enormous amount of traffic both in and out of New Zealand, all with the opportunity and potential to have a threat to our border. Can I congratulate and thank the officials for the fine work that they did during the Select Committee process. It was one of those times when there was a very good cross-party sort of approach to it, quite a good collegial understanding of the importance of it. And the Select Committee made some substantial recommendations, which I'm pleased to, and thank the Minister for, pleased to say were accepted by the government. The bill will now introduce a number of different things that weren't originally in the original proposal. And one of those is to recognise the status of land ownership, whether it be government, whether it be private, whether it be local government, and the effect, or the lack of effect actually, that has on a potential biosecurity breach. And so I'm sure that in fact there was a large amount of concern about the different policies for different types of land ownership structure prior to this bill. So I'm hoping that that will overcome some of those concerns. The biggest debate in the industry, I guess, or in the sector for the last 5 years has been the notion of a government sector partnership. And certainly right at the beginning of the debate there was quite a bit of reluctance on the part of various industry to be part of discussions in that. But if there's a lesson to be learnt from the recent kiwi fruit PSA incursion and the report that's subsequently come from that, it is that most of the institutional knowledge, or intellectual property if you like, in regard to what can be done, when and how, is in a lot of cases contained within the industry itself. And the government actually had a very good track record of working closely with the industry at that stage. So there's quite an irony, I think, at this point, looking at that report, to note that it was actually the horticultural industry that put up some of the strongest opposition to the idea of a government-industry partnership in the first stages. I'm not sure whether they still hold that view, and certainly most of the evidence would suggest that they probably don't now. So allowing that to happen and making sure that there's a legislative framework for a credible process to move forward and negotiate with the various sectors as to which part the industry will cover or hold the intellectual property rights in, and the pre-incursion discussions that must take place and agreements that must be reached, certainly in my view are going to enhance that. It's not a new idea. It is unique in some aspects, but it's not a new idea. In fact, in Australia they've been doing it in certain states for quite a while, and I think that New Zealand can only benefit from introducing these government industry partnerships. So I look forward to the discussions there. I heard the member who spoke before me mention foot and mouth. Well, clearly most industries would believe that if there were a major incursion that's well known with the type of economic effect that such an incursion as foot and mouth would have on New Zealand, then there would be an expectation, very high expectation, that the state would be there to respond quickly. But some of the less known and somewhat obscure incursions that are unlikely to have such a substantial effect on the New Zealand economy, but can have a devastating effect on an individual industry, most of the knowledge around what that might be or how to respond to it quickly and what the response should be, which in some cases is very much debated at the time of the incursion, is held within industry. It is impossible for former MAF, now primary industries, to have all of the intellectual property that is necessary on every single aspect of every single incursion that may affect a sector of our primary sector. Mr Chairman.
The Honourable Member Shane Ardern.
So, in my view, it is absolutely essential that that information is made available to the state through these industry agreements, and that takes place before the incursions take place as well, so that a predetermined agreement can be put in place. Mr Chairman, there are many other parts of this bill that I could speak on, and many other recommendations that were made by the Select Committee, but I know that my whip or the Minister won't thank me for taking up any more of the House's time. So to that end, I think it's a very good day that we are reaching a cross-party agreement on this, and I look forward to the passage of the bill through the Parliament.
I call the Honourable Member Moana Maki. Tēnā.
Thank you, Mr.